Trump and the Trump administration remained blocked from using the Alien Enemies Act to continue to deport people to one of the worst prisons in the world in El Salvador, a prison where more than 300 people have died in the last 2 years, to which the El Salvadorians say they all died of natural causes. Well, Chief Judge Boasberg of the D.C. District Court doesn't believe that, and he's keeping his injunction in place while there's a separate appellate hearing that took place earlier today, in which one of the appellate judges referred to the Trump administration and their actions towards these deported people as treating them worse than we treated the Nazis or suspected Nazis during World War II. I'm Michael Popok. Let's get to the new ruling by Judge Boasberg. He has, in a 37-page decision, he has upheld his earlier ruling to restrain the Trump administration for now to use the Alien Enemies Act to deport people. To make it clear, he is not stopping the Trump administration or forcing them to unlock the jails and let these suspected criminals out into the general population. He's not requiring that the Trump administration not process them appropriately with due process regards through immigration law and immigration courts. None of that. He's just saying that you can, in the middle of the night, shackle them, shave their heads, shove them into a dark, dank prison where they can die in El Salvador without due process. You know what we call that here in America? America. I'm Michael Popok. You're on Legal AF. Let's get to it again. On the memorandum that he just wrote, I want to read a couple of passages from it. First, the judge outlines how we got here and what the issues are that need to be resolved. The judge said and reminded everyone that the order, that the temporary restraining order he's keeping in place, neither required the government to release a single individual from its custody, neither order, the two of them that he issued, prevented the government from apprehending anyone pursuant to the just published proclamation. You want to round people up pursuant to the Alien Enemies Act? You can do that too. And the order did not prevent the government from deporting anyone, including the plaintiffs, through authorities other than the proclamation, such as the Immigration Act. It's just this lack of due process that's sticking in the judge's craw. Now, the judge went on to say that there needed to be hearings, there needed to be due process in order for this to go on. He then spent a certain amount of time, I think, previewing what will ultimately be a finding by him that the government, to purposefully try to get out from under the jurisdiction of this court, tried, knowing that the suit had been filed and the injunction was coming, sped up the process of getting them on planes and bringing them and deporting them to El Salvador. And the judge doesn't like any of that. He commented on page 5 of his order that even during World War II, when we had real enemy combatants and real enemies in Japan, Italy, and Germany, even then, President Roosevelt gave hearings and some sort of due process to those who were subject to the deportation order and the invocation of the Alien Enemies Act. On page 5, the judge says, while vigorously deploying the power, Roosevelt nonetheless provided for hearings for arrested alien enemies in order to permit them to present facts on their behalf, setting up these 3 to 6 civilian board members for that type of hearing. That's the reason why Judge Millett, in an appellate hearing today on this very issue about whether she was going to vote to keep this injunction in place or not while the appeal was going on, she said the Nazis were treated better. That's the reference in that particular brief. The page 6 talks about the judge kind of gets into whether he thinks he's been had and whether his orders have been violated. He says in the wee hours of last Saturday, the wee hours of Saturday morning, like 1 o'clock in the morning, 2 o'clock in the morning, plaintiffs filed this lawsuit and sought a temporary restraining order preventing the government from deporting them under the act until the claim could be heard. It's on page 6. From there, the judge says, bottom of page 6, events developed rapidly. Shortly after being assigned this case around 8 a.m. on March 15th, that's a week ago Saturday, this court contacted the government and connected with defense counsel at 9:20 a.m. By then, the court had informed the plaintiffs that at least one plaintiff had apparently been put on board an airplane along with other Venezuelans. It thus appeared This is the judge on page 7. That although the government knew of it thus appeared that although the government knew of the suit contesting the legality of removals under the proclamation, it was nonetheless moving forward with its summary deportation plan, meaning no hearings, no due process. After about an hour after now he holds a hearing last week. It starts at 5 o'clock. After an hour before the hearing began, the judge says around 4 p.m., Trump publishes the proclamation about the Alien Enemies Act, apparently having signed it the day before. So the plaintiffs and their lawyers at the American Civil Liberties Union were right. The judge said on page 8, in the 5 p.m. hearing, the court wanted to clarify the limited basis and scope of the TRO in place. The judge says on page 9 that he took a break, which I did not know about. At 5:22 p.m., the judge adjourned the hearing, took a break until 6 p.m., and directed the government to find out whether removing people under the proclamation was then in motion. Judge gives you an order to go do some fact-finding as an officer of the court. You better do it. But then on page 9, right under that, the court reveals that when the hearing resumed shortly after 6, the government surprisingly represented that it still had no details to share. On purpose, obviously. They were told by their higher-ups, the lawyers were told to shut their mouths and not respond to the judge's inquiry. The court thus returned to the venue issue. Noting that it was reasonably close question, he then goes into some procedural issues. At around 6:45, the court entered the temporary restraining order. The court therefore ordered that, this is at 6:45, that for 14 days the government was enjoined from removing any non-citizens in its custody solely on the basis of the proclamation. The court then told the government counsel, that's Drew Ensign, you shall inform your clients of the order immediately, and that any plane containing members of the class that is going to take off or is in the air needs to be returned to the United States. However that's accomplished, whether turning around a plane or not disembarking anyone, I leave it to you. But this is something that you need to make sure is complied with immediately. Not long after that, the court memorialized the order on the docket, referencing the hearing. That was at 7:25. See, the big issue here is that between 6:40, when he enjoined them, and 7:25, when he put it on the docket, the injunction still standing at 6:40. Looks like they were still launching at least 2 more planes that landed in Venezuela, and that is the subject of the contempt hearing, or the order to show cause hearing, that the judge is getting to the bottom of. I'll do a separate hot take about the Trump administration exercising or trying to exercise the state secrets privilege to avoid giving the judge any more information and keeping him in the dark. The judge went on page 10 to say it soon emerged that 2 planes were indeed likely in the air during the hearing. In other words, the government knew at 10 a.m., as of 10 a.m. on March 15th, that the court would hold a hearing later that day, and the most reasonable inference is that it hustled people onto those planes in the hopes of evading an injunction or perhaps preventing them from requesting the habeas hearing to which the government now acknowledges they are entitled. According to the government, prior to this court's oral ruling at around 6:45 p.m., 2 planes had departed the United States carrying persons designated as Tren de Aragua members, that's the Venezuelan gang, and deported based solely on the proclamation. Well, that seems to be a violation of the court's order, I would think. A 3rd plane left some hours later. Then the court goes on page 22, to talk about the political question issue. See, there's another defense that the Trump administration is raising, is that this is a political question doctrine issue, and under the political question doctrine, you, judge, can't interfere with the sole powers of the unitary president when it comes to foreign policy or war powers, so you got to back out. It's a political question. And the judge says, well, not exactly. There's a leading United States Supreme Court for the 1950s called Ludecky. And in Ludecky, actually from 1952, it was determined that one federal judge had the power and the duty and the authority to interpret whether a war proclamation, a war was still going on, to allow for the exercise of the Alien Enemies Act or not. That was something that isn't within a power of a judge to review that conduct of a president. So the Judge Boasberg says here on page 22, in light of Ludecky and the political question doctrines principles thus far explained, this court is confident that it can and therefore must, at the appropriate time, construe the terms nation, government, invasion, and predatory incursion. Whilst, and then they cite, this is very interesting, he cites to a case Loper Bright versus Raimondo, which is the case that came out in 2024 over the summer that the MAGA and the right wing was all excited about because it took away the Chevron doctrine, which was a doctrine that said you defer to administrative agencies. And Judge Roberts, in writing about Loper Bright, said, no, that is the purview of federal judges to declare what the law is and what words of the law means. And so Boasberg said, all right, I'm going to cite Loper Bright then for that precedent. I get to tell you what the words government, invasion, predatory incursion, and nation mean about whether you're using the Alien Enemies Act properly. And then finally, we get to page 35, when the judge has to consider whether irreparable harm is going to be done to these Venezuelans deported to this prison in El Salvador without, and there's a pay-to-play situation. El Salvador is being paid $6 million to fill their Supermax prison, which is empty, so that's also stinks. And the judge says, well, let's take a look at the prison for a moment. So on page 35, the judge says, one scholar offers that since March 2022, that's 2 years, an estimated 375 detainees have died in Salvadorian prisons. And then I think with a little bit of mock horror, the judge goes on to say, although the Salvadoran government maintains that all deaths have been natural, sure, 375 prisoners have just died in 2 years, all of natural causes. Others respond that 75% of them were, quote, violent, probably violent, or with suspicions of criminality on account of common patterns of hematomas, bleeding bruises on the body caused by beatings, sharp object wounds, and signs of strangulations. When an inmate is killed, there are also reports that guards bring the body back into the cells and leave it there until they start to stink. Needless to say, the judge continues, the risk of torture, beatings, and even death clearly and unequivocally supports a finding of irreparable harm. That's what the judge is trying to tell the world, that in America, whether we do it directly or indirectly, we don't beat our prisoners to death or subject them to that threat, especially without due process. And that's what this case is about. I'll do a separate hot take about what happened at the appellate court. This is the reporting now about what Judge Boasberg decided to keep that temporary restraining order in place while the appellate court decides whether to block it or not, while the full appeal happens, and then Donald Trump takes the invariable emergency application on this particular issue to the Supreme Court. I'll cover it all right here on Legal AF. Thanks for joining us. Take a moment and hit that subscribe button. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states. States and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.